Hello everyone, my name is Jing. I'm a licensed Chinese lawyer practicing in Shanghai as a litigator and a counsel. Quite a few times I've been asked by my client, especially foreign clients, to share those information, experience, and knowledge I've obtained from handling the cases for past few years. So I've decided to create this video to talk about those mostly asked questions from the past few cases. Okay, so today's topic is the mostly asked questions about labor contracts here in China. Okay, we know labor disputes is actually quite a complicated thing in China because we have two principal law here in China regulating labor issues. One is the labor law of China, and the other is the labor contract law. However, for foreign employees, the situation is quite different to the Chinese employees because when the Chinese employees have a dispute with their employers, these two laws will be automatically applied no matter whether they have concluded any clauses or not with their employer in their labor contract. However, for foreign employees, foreign workers, if you didn't have a clause for a specific issue with your employer, these two laws will not be automatically applied to solve the issue. For example, let's say when a Chinese employee does not have a severance clause with their employer for a situation like an early termination of the labor contract, when the contract is early terminated, they can always apply the labor law and labor contract law to claim for severance or compensation from their employer. However, if a foreign employee does not have such clause with the employer, they cannot actually use a Chinese labor law or labor contract law to claim for severance or compensation. So that's why situation for foreign workers here in China is quite different. Okay, so let's come to our today's topic. I've listed quite a few mostly asked questions here. I don't think I will go through them one by one to the time limits. Let me just pick a few of them to have it as a start. Okay, the first question mostly asked is who should sign a labor contract in written? Okay, so in a word, everyone, every single person, especially when you are a foreign worker here in Shanghai, in China, right? Everyone should sign a labor contract. If there is a labor relationship and money being transacted, it is official law that a written document must be in place to outline the terms of these transactions. As I just mentioned, the point is, if you don't really have clauses agreed prior to a dispute between you and your employer, as a foreign employee, you may face a problem that you got no ground to claim for the rights and the benefits that the law provides here. Okay? All right, the second question is, do I need to sign one with my ai or your security helper or your cleaning helper in your house? The answer is actually your relationship with your cleaning helper, your helper, is very different to the employment relationship that you have with your employer, because the relationship you have with your employer is an employment relationship, while the relationship between you and your ai, your helper, is a civil contract relationship. Okay, so the two different relationships are regulated under different law or by different laws. The former one is regulated by the labor contract law, the labor law, and your employment contract with your employer, while the later one is usually or generally regulated by the civil law here, the civil code in China. Okay, so you don't actually need to sign a labor contract with your helper. Instead, you usually need to sign a civil contract with your RE. Okay, and the easiest way to identify the difference between these two is to see whether you are paying social insurance to the person, the counterparty. If you're paying it, then probably you are an employer and the counterparty is an employee. But if you don't, you only pay by hours to the service that the counterparty has provided to you, then it's more like a civil contract. Okay? Right, let's see the third question. Do the labor contracts have to follow a certain structure? All right, as I just mentioned before, everyone needs a written contract, especially for employment here with your employer, especially for a foreign employee, right? But actually, the law doesn't really stipulate or outline a specific structure that the labor contract has to be, right? However, some of the elements are very important, such as the description of your job position, remuneration, benefits, working hours, and annual leave, and insurance. For these few elements, they are suggested to be stipulated and agreed in your contract, because those five, 6 elements are the most important like agreements that you should make with your employers. Okay, and other than this few, anything can be allowed to be agreed between you and the employer, right? And as I said, for a foreign employee, you are allowed to agree most of the things in written with your employers, but the law does say that there are 5 things that you are not to break the law provisions. Okay, they are the minimum salary, meaning that your employer cannot agree upon a lower salary less than the minimum number that each city had in their own regulation. Like Shanghai, we have a minimum salary provisions. I think it's about like 2,500 or 3,000 recently, meaning that your employer is not allowed to agree a lower number with you. Second, the maximum working hours. That point is slightly different in different cities. Like, for those outskirts cities, usually they will have less maximum working hours that the law will allow to be agreed than those top tier cities like Shanghai and Beijing. But generally, each city should have a maximum working hours number over there. Like in Shanghai, usually we have it around 40 to 50 hours per week. Okay. Third is the annual leave. Okay. The law does provide a minimum annual leave days, depends on the years that you have served as a employee to your employer. Okay, so your employer is not allowed to agree upon anything less than that. Let's say if based on the year they have served your job for your employer, your annual leave, the minimum annual leave of you stated by law is 10 days. Then your employer is not allowed to agree anything less than that. Okay. Fourth is your work safety condition. All right, so we do have a bottom line here for the basic safety condition here for each work position, and those things are not excluded between you and your employer. All right. The last thing is a social insurance. Your employer is not allowed to exclude those basic social insurance condition, and they are also not allowed to not paying the minimum number of social insurance to you. Usually that will be included in the deduction of your salary, but they're not allowed to not paying it, not affording it monthly for you. Okay? All right, so I think that's pretty much for today's topic. My name is Jing. I'm running a small team here, particularly serving expats and international clients for labor issues, commercial disputes, and criminal cases as well. All right, I see you next time. Thank you.